appear for the first and second respondent. As the pleases the court, I appear on behalf of the third, fourth, and fifth respondents. As it pleases the court, I appear on behalf of the sixth respondent.
As it pleases the court, I appear on behalf of the seventh respondent.
Thank you.
As it pleases the court, I appear on behalf of the eighth respondent.
Thank you. This bench is today handing down judgment in a matter that was reserved, wherein we promised we would hand it down this week, being the last week of the term of this year. Before I hand down the judgment, I prefer to read a summarized version thereof, and then we'll hand down the judgment. I must indicate that the judgment is unanimous, having been agreed to by all the members of this bench. In this matter, the President of the Republic of South Africa seeks to review the remedial action in the Public Protector's report, which was released on 2 November 2016 and entitled State of Capture. I refer to it as the report throughout the judgment. The report concerns an investigation conducted by the Public Protector into complaints of alleged improper and unethical conduct by the President, certain state functionaries, and the Gupta family, relating to the appointment of cabinet ministers and directors of state-owned entities, SOEs, which possibly resulted in the improper and corrupt award of state contracts and other benefits of businesses of the Gupta family. The remedial action directed the President to appoint a commission of inquiry to investigate the matters identified in the report. The President seeks to review and set aside paragraphs 8.4, 8.7, and 8.8 of the remedial action. The application is opposed by the current Public Protector, as well as the following political parties: the Economic Freedom Fighters, EFF, the United Democratic Movement, UDM, Congress of the People, COPE, and the Democratic Alliance, DA. The application is also opposed by Ms. Faki Mentor and a public benefit organization, the Council for the Advancement of the South African Constitution, CASAC. In the notice of motion, the President sought an order that the matter be remitted to the Public Protector for further investigation. This relief was based on the President's contention that the Public Protector did not have the power to delegate or outsource her functions to a commission of inquiry. The prayer for remittal prompted the Public Protector to deliver a conditional counter-application in which an order was sought, directing the President to ensure that the Public Protector was provided with sufficient funding to conduct the further investigation. During argument, the President's Counsel abandoned the prayer for remittal. Consequently, there is no longer any need for the Public Protector to proceed with the conditional counter-application, and the only issue that remains for consideration is the review of the specified parts of the remedial action. The report we are dealing with was issued by the Public Protector in terms of Section 182(1)(b) of the Constitution, Section 3(1) of the Executive Members Ethics Act, and Section 8(1) of the Public Protector Act. In March and April 2016, the public protector received 3 complaints in connection with alleged improper and unethical conduct in relation to the appointment of cabinet ministers and directors of SOEs and the award of state contracts and other benefits to the Gupta-linked companies. The complaints followed media reports alleging that the Deputy Minister of Finance, then Mr. Mcebisi Jonas, was offered the post of Minister of Finance by the Gupta family in exchange for a 600 million rands bribe. The offer allegedly took place at the Gupta residence in Saxonwell, Johannesburg, in the presence of Mr. Duduzane Zuma, the president's son. According to the report, the offer was allegedly made before his then colleague, Minister Nhlanhla Nene, was removed as Minister of Finance by the President on 9 December 2015. The report further refers to media reports that Ms. Mentor was offered the post of Minister of Public Enterprises in exchange for cancelling the South African Airways route to India, and that the President was at the Gupta residence when the offer was made. These cabinet positions were reportedly offered to Mr. Jonas and Ms. Mentor in exchange for furthering the interests of the Gupta family. It further appears from the report, referring to the media, that the relationship between the President and the Gupta family had evolved into state capture, underpinned by the Gupta family having power to influence the appointment of cabinet ministers and directors in boards of SOEs, and leveraging those relationships to get preferential treatment in state contracts, access to state-provided finance, and award of business licenses. The first complainant, Father S. Mayebe, on behalf of the Dominican Order, requested an investigation into the veracity of the Jonas and Mentor allegations, as well as an investigation into all business dealings of the Gupta family with government departments and SOEs to determine whether there were irregularities, undue enrichment, corruption, and undue influence in the awarding of contracts, mining licenses, government advertising in the New Age newspaper, and other governmental services. The second complainant, Mr. Musi Maimane, the leader of the DA, also relying on the same media reports, requested an investigation into the President's role in the alleged offer of cabinet positions to Mr. Jonas and Ms. Mentor, and that the investigation should look into the President's conduct in relation to the alleged corrupt offers and Gupta family involvement in the appointment of cabinet ministers and directors of SOE boards. In his complaint, Mr. Maimane stated, among other things, that the President may have acted improperly and in violation of the Executive Ethics Code. The third complaint, by a person whose name has been withheld, was based on media reports alleging that the cabinet had become involved in holding banks accountable for withdrawing banking facilities for Gupta-owned companies. The complainant wanted to know whether it was appropriate for cabinet to assist private business and on which ground that was happening. Based on an analysis of these complaints, the public protector identified the following issues as relevant for investigation: whether the President had breached the Ethics Act and had acted improperly and in violation of the Ethics Code, whether the President had allowed members of the Gupta family and his son to be involved in the process of removal and appointment of the Minister of Finance in December 2015, whether the President allowed members of the Gupta family and his son to engage or be involved in the process of removal and the appointment of various members of cabinet, whether the President had allowed members of the Gupta family and his son to be involved in the process of appointing members of boards of directors of SOEs, whether the President had enabled or turned a blind eye in violation of the Ethics Code to allege corrupt practices by the Gupta family and his son in relation to allegedly linking appointments to quid pro quo conditions, whether the President had improperly and in violation of the Ethics Code exposed himself to any situation involving the risk of conflict between his official duties and his private interests, or used his position or information entrusted to him to enrich himself and businesses owned by the Gupta family and his son, to be given preferential treatment in the award of state contracts, business financing and trading licenses, whether the President had prejudiced anyone by his conduct, and whether other cabinet ministers had improperly interfered with the relationship between banks and Gupta-owned companies, and thus giving preferential treatment to such companies on matters that should have been handled by independent regulatory bodies. The Public Protector also identified the following further issues for investigation: whether any state functionary in any organ of state or other person had acted unlawfully, improperly, or corruptly in connection with the appointment or removal of ministers and directors or boards of directors of SOEs, whether any state functionary in any organ of state or other person acted unlawfully, improperly, or corruptly in connection with the awarding of state contracts or tenders to Gupta-linked companies or Gupta-linked companies or persons, any state functionary in any organ of state or other person acted unlawfully, improperly, or corruptly in connection with the extension of state-provided business financing facilities to Gupta-linked companies or persons, any state functionary in any organ of state or other person acted unlawfully, improperly, or corruptly in connection with exchange of gifts in relation to Gupta-linked companies or persons, and whether any person, entity was prejudiced due to the conduct of the SOE. I move now to the investigation. It is necessary to also deal with the contents of the report with regard to the investigation that was carried out. Because of the statutory obligation under the Ethics Act to submit a report within 30 days, the Public Protector immediately commenced to interact with the President. On 22 March 2016, the Public Protector wrote to the President advising him that she had received a request from the DA and the Dominican Order to conduct an investigation into an alleged breach of the Ethics Code arising from the President's alleged role in the offering of ministerial positions by members of the Gupta family. She asked the President, and I quote, "If you have any comments on the allegations leveled against you, I would appreciate a letter indicating such comments from you." I close quotes. This letter apparently did not reach the President. On 22 April 2016, the Public Protector again sent the letter to the President in which she also advised him that the investigation had not been completed due to inadequate resources. This letter was received by the President. The Public Protector received no response from the President, and by early September 2016 had not received additional funds in order to proceed with the investigation. On 13 September 2016, the Public Protector sent another letter to the President requesting a meeting with him in order to brief him on the investigation and affording him a further opportunity to comment on the allegations to the effect that the president ought to have known and or allowed his son to exercise undue influence in strategic ministerial appointments as well as board appointments at SOEs. The public protector elected to combine the three complaints and divided the investigation into two phases. She explains that the investigation was divided into two phases in order to accommodate the time and resource limitations by addressing the pressing questions threatening to erode public trust in the executive and SOEs, while mapping the process for the second and final phase of the investigation. The investigation process included correspondence with key parties implicated by the allegations and potential witnesses. Interviews were conducted with key witnesses, commencing with Mr. Jonas and Ms. Mentor, who confirmed their status as whistleblowers. The investigation team also interviewed Mr. Maseko, who was identified by the media as a whistleblower. Interviews were also conducted with several other ministers and selected witnesses. Documents were requested from appropriate persons and institutions. These were analyzed and evaluated together with the oral evidence to establish if any of the allegations could be corroborated. Towards the conclusion of the investigations, persons who appeared to be implicated by the evidence collected were served with notices in terms of Section 7(9) of the Public Protector Act to apprise them of such evidence, the potential of adverse findings being made, and to afford them the opportunity to respond. It appears from the report that in his interview, Mr. Jonas confirmed the media reports concerning the offer to be appointed as Minister of Finance. Similarly, the report mentions that in her interview, Ms. Mentor confirmed the media reports about the offer made to her. The public protector also issued subpoenas and procured documentation concerning the issues raised in this part of the investigation. These are detailed in the report. In regard to the complaints made by Mr. Jonas and Ms. Mentor, the public protector obtained and analyzed the cell phone records of persons who had been implicated. These included Mr. Duduzane Zuma and Mr. Hlongwane. She also secured, by means of a subpoena, the cell phone numbers of Minister van Rooyen. The public protector sets out in detail the telephone discussions and text messages that passed between these persons. She points out that these communications appear to confirm Mr. Jonas's version of events. The public protector interviewed Mr. Tembo Maseko, as stated, the former CEO of Government Communication and Information System. She states in the report that he allegedly received a telephone call from the president telling him to help the Gupta family. It appears from the report that the Gupta family instructed him to direct government departments to send advertising to the newspaper, The New Age, in contravention of procurement guidelines. He was thereafter reportedly removed from his position. A large part of the report centers around alleged irregularities in the awarding of contracts by Eskom to Tegeta and Optimum Coal Pty Limited, who we refer to as Optimum. In addition, the public protector also investigating the sale of all shares held by Optimum Coal Holdings, whom we refer to as Optimum Holdings. The public protector states that the first phase of her investigation did not touch on the award of licenses to the Gupta family and superficially touched on state financing of the Gupta-Zuma business, while only selecting a few state contracts. She also sets out the issues reserved for the next phase of the investigation. She states that it was not possible for her to investigate all the issues before her due to lack of resources. I now deal with some of the critical observations made by the public protector found in paragraph 7 of the report. She says in that paragraph, having considered the evidence uncovered during the investigation against the relevant regulatory framework, I make the following observations. In regard to the question whether the President improperly and in violation of the Ethics Code allowed members of the Gupta family and his son to be involved in the process of removal and appointment of the Minister of Finance in December 2015, the public protector says the following, and I quote selected parts. President Zuma was requested to select and appoint ministers and in compliance with the Executive Ethics Code. It is worrying that the Gupta family was aware, or may have been aware, that Minister Nene was removed 5 weeks after Deputy Minister Jonas advised him that he had been allegedly offered the job by the Gupta family in exchange for extending favors to their family business. Equally worrying is that Minister Van Rooyen, who replaced Minister Nene, can be placed at the Saxonwald area on at least 7 occasions, including on the day before he was announced as minister. This looks anomalous, given that at the time he was a member of parliament based in Cape Town. Another worrying coincidence is that Minister Nene was removed after Mr. Jonas advised him that he was going to be removed. If the Gupta family knew about the intended appointment, it would appear that information was shared then in violation of the Executive Ethics Code, which prohibits members of the executive from the use of information received in confidence in the course of their duties or otherwise than in connection with the discharge of their duties. I close quote. As to the question whether the President had improperly and in violation of the Ethics Code allowed members of the Gupta family and his son to engage or to be involved in the process of removal and appointing of various members of cabinet, the public protector points out that there is no evidence of action taken to verify either Mr. Jonas or Ms. Mentor's allegations. If this is the case, the public protector says, the President may have violated the Ethics Code, which prohibits a member of the executive from acting in a way that is inconsistent with their position. She says there may even have been a violation of the code which prohibits a member of the executive from using information received in confidence in the course of their duties, otherwise than in connection with the discharge of their duties. The public protector expresses the view that if Mr. Jonas's allegation that he was offered the position of minister for him being required to extend favors to the Gupta family is correct, this may constitute an infringement of the provisions of Section 34 of the Prevention and Combating of Corrupt Activities Act, which places a duty on persons in positions of authority who know or ought reasonably to have known or suspected that any other person has committed an offense under the Act to report such knowledge or suspicion to a police official. A similar duty, so the report says, is imposed and possibly violated in relation to the allegations that were made by Mr. Maseko. The public protector further states that the allegations raised by Mr. Jonas and Mr. Maseko are relevant to the question whether the President improperly and in violation of the Ethics Code exposed himself to a situation involving the risk of conflict between his official duties and his private interest. The public protector is also of the view that the allegations made by Ms. Hogan also deserve a closer look to the extent that they suggest executive and party interference in the management of SOEs and appointments thereto. Another aspect that the public protector gave consideration to was whether the president and other cabinet ministers had improperly interfered in the relation between banks and Gupta-owned companies, thus giving preferential treatment to such companies on a matter that should have been handled by independent regulatory bodies. She points out that the cabinet appears to have taken an extraordinary and unprecedented step regarding intervention into what appears to be a dispute between a private company co-owned by the president's friends and his son. This, the public protector says, needs to be looked at in relation to a possible conflict of interest between the president as head of state and his private interest as a friend and father, as envisaged under the Ethics Act and Ethics Code and Section 195 of the Constitution, which requires a high level of professional ethics. The public protector points to the prepayment by Eskom of 659,558,000 as an example of the way in which a state-owned entity acted unlawfully, improperly, or corruptly in connection with the award of state contracts or tenders to Gupta-linked companies or persons. I now turn to the remedial action that is impugned in this litigation. The remedial action proposed by the public protector reads as follows, and I quote, "The appropriate remedial action I am taking in pursuit of Section 182(1)(c) of the Constitution, with a view of placing the complainant as close as possible to where he would have been had the improper conduct or maladministration not occurred, while addressing systemic procurement management deficiencies in the department, is the following. To the President, investigation has proven that the extent of issues it needs to traverse and resources necessary to execute, it is incapable of being executed fully by the public protector. This was foreshadowed at the commencement of the investigation when the public protector wrote to government requesting for resources for a special investigation similar to a commission of inquiry overseen by the public protector. This investigation has been hamstrung by the late release, which caused the investigation to commence later than planned. The situation was compounded by the adequacy of the allocated funds, which was 1.5 million rands. In 8.3, the President has the power under Section 84(2)(f) of the Constitution to appoint commissions of inquiry. However, in the EFF versus Speaker of the Parliament, the President said that I could not have carried out the evaluation myself lest I be accused of being judge and jury in my own case. 8.4, the President to appoint within 30 days a commission of inquiry headed by a judge solely selected by the Chief Justice, who shall provide it one name to the President. The judge to be given the power to appoint his or her own staff and to investigate all the issues using the record of this investigation and the report as a starting point. The Commission of Inquiry to be given powers of evidence collection that are no less than that of the Public Protector. The Commission of Inquiry to complete its task and to present the report with findings and recommendations to the President within 180 days. The President shall submit a copy with an indication of his/her intentions regarding the implementation to Parliament within 14 days of releasing the report. I close quote there, and I don't read the other parts of the remedial action. I now turn to the grounds of review relied on by the President. The review is essentially directed at the lawfulness and rationality of the remedial action. Broadly stated, the grounds of review are the following. The Constitution vests the power to appoint the Commission of Inquiry in the President. Only he can exercise that power, and it is unconstitutional for the Public Protector to instruct him to do so. The President asserts that if he complied with the remedial action, his decision would be reviewable because it would have been taken under the dictate of another and would be an abdication of his power under Section 84 of the Constitution. Next. The direction that the Chief Justice appoint the judge to head the Commission of Inquiry is unlawful, as the Constitution does not assign this power to the Chief Justice. The direction is also irrational, as there is no reason to suggest that a judge selected by the President would not be independent and impartial. Next. It is beyond the powers of the Public Protector to give directions as to the manner in which the Commission of Inquiry is to be implemented. It is the President's prerogative to select the officer to preside over the Commission, and it is also the President alone who can decide upon the issues that the Commission is to investigate, its powers, and when the Commission is to complete its investigation. Next. The remedial action constitutes an unlawful delegation of the Public Protector's investigatory powers to a Commission of Inquiry. It is inconsistent with the Ethics Act and the Public Protector Act because those statutes require the Public Protector herself to undertake the investigation of the complaints. The remedial action improperly outsources the investigation, which is contrary to these statutes. Next. The remedial action is inconsistent with the Ethics Act, which requires that the Public Protector investigate a breach of the Code of Ethics. Section 3 of the Ethics Act requires that the Public Protector must investigate a complaint lodged in terms of the Act. It does not permit the Public Protector to require another body, such as a Commission of Inquiry, to complete the investigation into a complaint. The Public Protector has impermissibly delegated or outsourced her function under the Ethics Act to a Commission of Inquiry. Furthermore, a Commission of Inquiry does not have the same powers as a Public Protector and cannot take remedial action. This would run counter to the powers and purpose of the Public Protector under the Ethics Act. Next. The Public Protector only has the power to take remedial action where an investigation has been completed and findings of impropriety or prejudice have been made. The remedial action taken is not appropriate as required by the Constitution, as the investigatory process has not been completed and the Public Protector has not made any findings of impropriety or prejudice. It is also impermissible for the Public Protector to order the President to exercise an executive power, as this offends against the separation of powers doctrine. Next. The remedial action was irrational, as the Public Protector decided to outsource the investigation to a Commission of Inquiry based on an alleged lack of resources. If this were true, the rational decision to have made was to approach Parliament for funds. The remedial action was also irrational, as it was based on the pending end of Advocate Madonsela's term and the limited qualifications of her successor, Advocate Mkhwebane. Those are the grounds upon which the remedial action is sought to be impugned. The primary question that is pertinently raised in this case is whether the President's constitutional power to appoint a Commission of Inquiry can permissibly be limited by remedial action taken by the public protector. Section 84(2)(f) confers upon the President the power to appoint a commission of inquiry. It is an original constitutional power that vests in the President as head of state. The power to appoint a commission of inquiry vests in the President alone, and only he can exercise that power. Does it not follow, therefore, as the President asserts, that there are no constraints upon the exercise of the Section 84(2)(f) power? We demonstrate in the discussion that follows that there are constraints to the exercise of this power. Under our constitutional order, the exercise of all public power is subject to the provisions of the Constitution, which is the supreme law. The powers accorded to the President in Section 84(2) of the Constitution cannot be viewed in isolation. Account must be paid to the structure and design of the Constitution, the role that different organs of government play, and the value system articulated in Section 1 of the Constitution and the Bill of Rights. Supremacy of the Constitution, accountability, and the rule of law are foundational values that lie at the heart of the Constitution. In terms of Section 83(b) of the Constitution, an obligation is expressly imposed on the President to uphold, defend, and respect the Constitution as the supreme law of the Republic. And Section 7(2) of the Bill of Rights binds the President as an organ of state to respect, protect, promote, and fulfill the rights contained in the Bill of Rights. The principle of legality, being an incident of the rule of law, dictates that those who exercise public power, including the President, must comply with the law. The role of the rule of law as a form of constitutional control on the exercise of public power was given expression in the case of Affordable Medicines Trust and another versus Minister of Health and another, where former Chief Justice Ngobo stated, and I quote, "The exercise of public power must therefore comply with the Constitution, which is the supreme law, and the doctrine of legality, which is part of the law. The doctrine of legality, which is an incident of the rule of law, is one of the constitutional controls through which the exercise of public power is regulated by the Constitution. It entails that both the legislative and the executive are constrained by the principle that they may exercise no power and perform no function beyond that conferred upon them by law. In this sense, the Constitution entrenches the principle of legality and provides the foundations for the control of public power." I close quotes. The constitutional role of the President was aptly described by the Constitutional Court in another case, the President of the Republic of South Africa and another versus Hugo, where that court said, ultimately, the President, as the supreme upholder and protector of the Constitution, is its servant. Like all other organs of state, the President is obliged to obey each and every one of its commands. I close quotes. That the President does not enjoy untrammeled powers is to be inferred from the wording of Section 84 of the Constitution. The section is cast in obligatory language. Counsel for the President submitted that Section 84(2)(f), which confers on the President the power to establish a commission of inquiry, does not impose a duty, but merely a power, which the President may exercise at his discretion. Reliance was placed for this submission on a dictum in the case of Daniels versus President of the Republic of South Africa. The reliance on Daniels is misplaced. To sum up, even though the Constitution vests in the President the power to appoint a Commission of Inquiry, this power is not an untrammeled one. It must be exercised within the constraints that the Constitution imposes. The President's power to appoint a Commission of Inquiry will necessarily be curtailed where his ability to conduct himself without constraint brings him into conflict with his obligations under the Constitution. I turn now to the President's challenge to the powers of the Public Protector. The Public Protector is one of the institutions created under Chapter 9 of the Constitution to strengthen constitutional democracy. The Public Protector is required to be independent and subject only to the Constitution and the law, to be impartial and exercise her powers and functions without fear, favor, or prejudice. In the case of economic freedom fighters versus Speaker, National Assembly, and others, at paragraph 51, and we refer to this case as the EFF case, the Constitutional Court held that the mandate of the Public Protector is to protect the public from any conduct in state affairs or in any sphere of government that could result in any impropriety or prejudice, unlawful enrichment and corruption, to report on its investigations and take appropriate remedial action. The Public Protector Act confers additional powers and functions on the Public Protector. The investigative powers conferred on the Public Protector are of the widest ambit. In a footnote, the court in the EFF case said the following concerning the powers of the Public Protector, and I quote, "All the powers set out in Section 6 accord and are harmoniously coexistent with Section 182. Powers of functions have thus either been added or regulated. Mediation, conciliation, negotiation, and giving advice to a complainant regarding how best to secure an appropriate remedy, bringing what appears to be an offense to the attention of the prosecuting authority, referring a matter to an appropriate body or authority, or making suitable recommendations to remedy the complaint, and resolving any complaint by any other means that may be expedient in the circumstances, are all regulatory and additional powers, and they are consistent with and flow from the constitutional power to take appropriate remedial action and provision for additional powers and functions." In Section 7, the Public Protector Act gives the Public Protector extensive investigatory powers. Section 182(1)(c) of the Constitution provides that the Public Protector has the power, as regulated by national legislation, to take appropriate remedial action. The phrase "take appropriate remedial action" is of importance. It connotes providing a proper, fitting, suitable, and effective remedy for whatever complaint and against whomsoever the Public Protector is called upon to investigate. What remedial action is taken in a particular case depends on the nature of the issues under investigation and the type of findings made. In the EFF case, the Constitutional Court, stated the following concerning the exercise and legal effect of the remedial power, and I quote, "The primary source of the power to take appropriate remedial action is the supreme law itself, whereas the Public Protector Act is but a secondary source. It is exercisable only against those that she is constitutionally and statutorily empowered to investigate. Implicit in the words 'take action' is that the Public Protector is herself empowered to decide on and determine the appropriate remedial measure and action presupposes, obviously, where appropriate, concrete or meaningful steps. Nothing in these words suggests that she necessarily has to leave the exercise of a power to take remedial action to other institutions, or that it is power that is by its nature of no consequence. She has the power to determine the appropriate remedy and prescribe the manner of its implementation. Appropriate means nothing less than effective, suitable, proper, or fitting to redress or undo the prejudice, impropriety, unlawful enrichment, or corruption in a particular case. Only when it is appropriate and practicable to effectively remedy or undo the complaint would a legally binding remedial action be taken. Also informed by the appropriateness of the remedial measure to deal properly with the subject matter of investigation and in line with the findings made, would be a non-binding recommendation be made or measure taken. Whether a particular action taken or measure employed by the public protector in terms of a constitutionally allocated remedial power is binding or not, or what its legal effect is, would be a matter of interpretation aided by context, nature, and language. I close quotes. As is evident from the foregoing, the public protector's investigative powers are of the widest character. In order to fulfill this role, the public protector is empowered to take binding remedial action that is capable of remedying the wrong in the particular circumstances. This must include directing or instructing members of the executive, including the president, to exercise powers entrusted to them under the Constitution where that is required to remedy the harm in question. In the EFF case, the Constitutional Court emphasized that although the public protector's powers to take appropriate remedial action is wide, it is certainly not unfettered. The remedial action is always open to judicial scrutiny. It is also not inflexible in its application, but situational. What remedial action is appropriate in a particular case depends on the nature of the issues under investigation and the findings made. Remedial action is therefore context-specific. Adopting a purposive interpretation of the relevant statutory framework, it is plain that the public protector must, if she is to properly fulfill her constitutional mandate, have the power in appropriate circumstances to direct the President to appoint a commission of inquiry and to direct the manner of its implementation. Any contrary interpretation would be inconsistent with the Constitution as aptly pronounced by the Constitutional Court in the EFF case, and would render the public protector's power to take remedial action largely meaningless or ineffectual. For these reasons, it follows that the primary ground of review that it is unlawful for the public protector to instruct the President to appoint a commission of inquiry, no matter how compelling the circumstances may be, is without merit and must be rejected. I turn to the unlawful delegation ground. The President advances the argument that the remedial action constitutes an unlawful delegation of the public protector's powers under the Constitution and Section 7.3 of the Public Protector Act to a commission of inquiry. This argument misconceives the manner in which the public protector has exercised her powers. The public protector has not delegated her investigatory powers to a commission of inquiry. She did what she is empowered and mandated to do in terms of Section 182(1) of the Constitution. She investigated the 3 complaints of state capture laid before her to the extent that this was possible, made prima facie findings on the basis of her investigation, and took remedial action directing the President to establish a commission of inquiry to complete the second phase of the investigation. An investigation may take many forms, and it is for the public protector to decide what is appropriate in each case. Because of the financial and other constraints mentioned in the report, the public protector considered it appropriate that the second phase of the investigation into allegations of state capture be undertaken by a commission of inquiry. There is nothing in either the Public Protector Act or Ethics Act that prohibits the public protector from instructing another organ of state to conduct a further investigation. The Public Protector Act expressly empowers the public protector to obtain assistance in her investigations. The Act envisages that the public protector will exercise her powers with the assistance of other relevant entities. It expressly allows her to require other parties to make appropriate recommendations after she has concluded an investigation. Consequently, this ground of review cannot be sustained. Inconsistency with the Ethics Act is another ground advanced by the President. He argues that the remedial action is inconsistent with the Ethics Act because a commission of inquiry is unable to investigate a breach of the ethics code. This, he argues, only can be done by the public protector. He places reliance on Section 3 of the Ethics Act, which provides that the public protector is to investigate breaches of the code, of the ethics code. Sorry. Where am I? Pardon me, what paragraph?
96.
Yeah, no, sorry. Go ahead. Pardon me. I'm going there. This argument is misconceived. Section 3 of the Ethics Act provides that when conducting an investigation in terms of this section, the public protector has all the powers vested in the public protector in terms of the Public Protector Act. The public protector has in fact investigated the complaints and performed her duty under the Ethics Act. As empowered to do, she has taken binding remedial action on the basis of her investigation and the prima facie findings of wrongdoing that she has made. The public protector has considered appropriate that a commission of inquiry complete the second phase of the investigation, which will also give consideration to the question whether the President has breached the ethics code. It is further argued by the President that the remedial action is inconsistent with the Ethics Act because a commission of inquiry would be unable to take remedial action. This argument is also misconceived. The public protector's power to take remedial action stems from the Constitution and not from the Ethics Act. Acting in terms of a constitutional power, the public protector took binding remedial action on the basis of her investigation and the prima facie findings made. I turn to the argument that findings of impropriety or prejudice had to be made. Counsel for the President argued that the remedial action is unlawful because the public protector did not make findings of impropriety or prejudice. He submitted that such a finding is a jurisdictional fact necessary for the public protector to take remedial action. It was also argued that there must be an appropriate nexus between the finding of impropriety or prejudice and a remedy to correct the improper conduct found to have been committed. On a proper interpretation of Section 182(1) of the Constitution, read with the relevant provisions of the Public Protector Act, the taking of remedial action by the public protector is not contingent upon a finding of impropriety or prejudice. The public protector's powers are clearly set out in Section 182(1) of the Constitution. There is nothing in the wording of the section that links the remedial action to a finding of improper conduct. It is clear from the wording of the section that the public protector is afforded three separate powers. One, to investigate conduct that is alleged or suspected to be improper. Two, to report on that conduct. And three, to take appropriate remedial action. Section 8(1) of the Public Protector Act reads as follows, and I quote, "The public protector may, in the manner he or she deems fit, make known to any person any finding, point of view, or recommendation in respect of a matter investigated by him or her." Thus, the public protector is expressly empowered to make findings or recommendations, read together with the public protector's constitutional powers to take binding remedial action. The public protector is constitutionally and statutorily empowered to take such action on the basis of preliminary or prima facie findings. The primary role of the public protector is that of an investigator and not an adjudicator. Her role is not to supplant the role and function of the courts. It is common cause that the report does not reach any firm findings on whether the evidence collected established wrongdoing by the President, the Gupta family, and others. But that does not preclude the public protector from taking appropriate remedial action. The public protector's observations set out in paragraph 7 of her report constitute prima facie findings that point to serious misconduct or impropriety on the part of the President. The Gupta family and the persons, functionaries, and entities referred to in the report. These observations are supported by a considerable body of corroborative evidence. Beg your pardon. What considerably strengthens the prima facie case of misconduct and impropriety is the failure of the President to address the complaints when requested by the public protector to do so. The prima facie evidence which points to serious state misconduct is a sufficient and appropriate basis for the public protector to have taken the remedial action. The President's argument, therefore, that the remedial action is unlawful because the public protector did not make findings of misconduct and impropriety is groundless and must also be rejected. Was the remedial action appropriate? Section 182(1) of the Constitution enjoins the public protector to take appropriate remedial action. Relying on what was stated in the case of Force versus Minister of Safety and Security, the Constitutional Court in the EFF case emphasized that the taking of appropriate remedial action connotes providing a proper, fitting, suitable, and effective remedy for whatever complaint and against whomsoever the public protector is called upon to investigate. The public protector is constitutionally empowered to take action that has that effect if it is the best attempt at curing the root cause of the complaint. The allegations of state capture detailed in the report are extremely serious. They amount to allegations that the President and members of the executive have exercised their powers, at least on occasion, not in the public interest, as they are required to do under the Constitution, but rather at the behest of a private family and to further its financial interests. The public protector has made a number of damning findings against the President. Mr. Jonas's allegation that he was offered money and a ministerial post by members of the Gupta family in exchange for favors has never been investigated by the President or any other member of the executive, notwithstanding a legal obligation to do so. The offer of a ministerial appointment to Mr. Jonas was allegedly made some 6 weeks before the removal and appointment of the Minister of Finance in December 2015. The public protector held the view that if the Gupta family knew of the pending removal and the appointment of a new Minister of Finance, as is suggested by Mr. Jonas, this information could only have been imparted to them by the President. Her prima facie finding was that the sharing of such information constitutes a violation of the Executive Ethics Code. It may also have constituted a violation of Section 2.3e, which prohibits a member of the executive from using information received in confidence in the course of their duties, otherwise than in connection with the discharge of their duties. The failure to verify Mr. Jonas's allegations may also have infringed the provisions of Section 34 of the Prevention and Combating of Corrupt Activities Act. Ms. Mentor, according to the report as stated, was allegedly offered the position of Minister of Public Enterprises in exchange for the favor of cancelling the SAA route to India. This offer, according to the report, was made by a member of the Gupta family at the Gupta family residence in Saxon World while the President was there. The public protector holds the view that if Ms. Mentor's evidence is true, the offer of a cabinet position could only have been made with the knowledge and approval of the President. Again, the public protector notes that there may have been a violation by the President of the Executive Ethics Code. The public protector also notes that there is no evidence of action taken by anyone to verify Ms. Mentor's allegations. The public protector notes that a similar duty may possibly have been violated by the President in relation to the allegations made by Mr. Themba Maseko. The report points to the existence of evidence that the President and other cabinet members improperly interfered in the relationship between banks and Gupta-owned companies. The report states the cabinet appears to have taken the extraordinary step and unprecedented step regarding intervention into what appears to be a dispute between a private company co-owned by the President's friends and his son. She observed that this needs to be looked at in relation to a possible conflict of interest between the President as head of state and his private interest as a friend and father, as envisaged in the Executive Ethics Code. The public protector makes the observation that ESCOM and other state-owned entities may have acted unlawfully, improperly, or corruptly in connection with the award of state contracts or tenders to Gupta-linked companies or persons. She states that there is irrefutable evidence that the board of ESCOM in December 2014 consisted predominantly of individuals with direct and indirect business or personal relationships with the President's son, Mr. Duduzane Zuma, the Gupta family, and their related associates. The public protector conducted a detailed investigation of irregularities, employment of board members, the award of certain contracts by ESCOM to Optimum Coal, and the sale of shares held by it to Tegeta. The report highlights how the Gupta family used its influence to obtain business contracts with ESCOM. ESCOM awarded Tegeta contracts and made payments to it of over 1.2 billion rands. Of particular concern to the public protector was the prepayment to Tegeta in the amount of 659,558,000 rands. The public protector found that the sole purpose of the prepayment was to enable Tegeta to purchase the sale in Optimum Holdings. This payment amounted to a possible contravention of Section 38 and 51 of the Public Finance Management Act. The Public Protector is particularly critical of the conduct of Mr. Brian Molefe, the then CEO of Eskom. She pointed out that in the days leading up to the Eskom board resolution to pay the prepayment to Tegeta, Mr. Molefe was placed in the Saxonwold area on numerous occasions and in communication with Gupta family members. And she also noted that the president's son, Mr. Duduzane Zuma, is a shareholder in Tegeta. On the basis of the extensive evidence placed before her, the Public Protector makes the observation that Tegeta's conduct and misrepresentation made to the public with regard to the prepayment and the actual reason for the payment could amount to fraud. There is thus compelling prima facie evidence that the relationship between the President and the Gupta family, so says the Public Protector, had evolved into state capture underpinned by the Gupta family having power to influence the appointment of cabinet ministers and directors in boards of SOEs and leveraging those relationships to get preferential treatment in state contracts, access to state-provided business finance, and the award of business licenses. The issue of state capture is a matter of great public concern. The outcome of her investigation is that there is deeply concerning evidence of serious malfeasance and corruption, but she does not have the resources to complete the investigation. She has reasoned that a commission of inquiry is the appropriate remedial action in light of her findings and constraints. In order to determine whether the Public Protector's remedial action was lawful and rational, it is necessary to understand what role a commission of inquiry plays, how it performs that role, and why it is better suited at accomplishing certain ends than the Public Protector. I can do no better than quote the Constitutional Court decision in Minister of Police and others versus Premier of the Western Cape and others. There, the court said, and I quote, "In addition to advising the executive, a commission of inquiry serves a deeper public purpose, particularly at times of widespread disquiet and discontent. One of the primary functions of public inquiries is fact-finding. They are often convened in the wake of public shock, horror, disillusionment, or skepticism in order to uncover the truth. In times of public question, stress, and concern, they provide the means to be appraised. They provide the means, for Canadians, this is reference to a Canadian case, to be appraised of the conditions pertaining to a worrisome community problem and to be a part of the recommendations that are aimed at resolving the problem. Both the status and high public respect for the Commissioner and the open and public nature of the hearing help to restore public confidence, not only in the institution or situation investigated, but also in the process of government as a whole. They are an excellent means of informing and educating concerned members of the public." I close quote. This was a quotation used by the Constitutional Court from a Canadian case. The Constitutional Court had further statements to make about a commission of inquiry. This was in the Magidi one and others versus President of the Republic of South Africa and others case. There, the court stated, "It is open to the President to search for the truth through a commission, the truth so established could inform corrective measures, if any are recommended, influence future policy, executive action, or even the initiation of legislation. A commissioner's search for the truth also serves indispensable accountability and transparency purposes. Not only do the victims of the events investigated and those affected need to know the truth, the country at large does so too, I close quotes. In the Azapo case, which was referred by the Constitutional Court there described the role of commissions as also encompassing a national catharsis and accountability element. In order to achieve the goals of truth-finding and restoring confidence, it is necessary that those who head the commission be perceived as independent and that the proceedings be conducted in public. Sitting and retired judges are often used as commissioners as they have both institutional and financial independence. Moreover, they have the forensic skills necessary to gather and evaluate large quantities of evidence. Commissions of inquiry are by their nature open and transparent. Their sittings occur in public. The matters reserved by the public protector for the second phase of the investigation are extensive. In her answering affidavit, the public protector states that it is not possible for the Office of the Public Protector to finalize the investigation due to a lack of resources. The Good Governance and Integrity Unit is a unit within the Office of the Public Protector which specifically deals with matters involving conduct failure, maladministration, and corruption in state affairs. Currently, so the report records, this unit is composed of 8 senior investigators who are investigating more than 288 complex cases involving conduct failure, maladministration, and corruption. On average, the report states, each investigator carries 36 cases for investigation. As a result, it takes an average of between 2 to 4 years for an investigator to finalize an investigation of a complaint. There is simply, so the public protector says, no capacity to conduct an investigation of the scale that would be required. The public protector estimates that she will need a total of 16 additional investigators, the salary cost of which would amount to some 21 million rands. In addition, the public protector would require additional funding for specialized expert services, such as forensic and audit investigations, which he estimates the funding required for this service would amount to some 10 million rands. In all, the total financial resources required to conduct the investigation would amount to some 31 million rands. All of these considerations lead ineluctably to the conclusion that a judicial commission of inquiry is by its nature preeminently suited to carry out the task of investigating the allegations of state capture contained in the report. I turn to the President's attack on the direction that the Chief Justice is to select the judge who must preside over the Commission of Inquiry. The rationale that underpins the public protector's direction that the judge who is to head the commission be appointed by the Chief Justice is clear. The public protector foresaw that the credibility of the process may be compromised were the President to select the judge who is to lead the commission. She would undoubtedly have been aware that public perception is important too and is linked to encouraging public faith in the process. By all accounts, the President has a clear personal interest in the outcome of the commission. The President is implicated in the state capture report and is at the center of the allegations regarding the Gupta family's involvement in the appointment of cabinet ministers. Moreover, his son's business interests are heavily implicated by the allegations regarding the award of contracts by SOEs to Gupta-owned businesses. Any person chosen by the President to head the commission would therefore not be perceived as independent. There is much force in the argument that the President should recuse himself from appointing a judge in order to exclude any perception of bias and to protect the integrity of the Commission in the eyes of the public. The President's insistence that he alone select a judge to head the Commission of Inquiry is at odds with the legal principle of recusal. There is no reason why the recusal principle should not apply to the President. The principle of recusal applies here because the President has an official duty to select a judge to lead the commission, but he is conflicted as he himself has been personally implicated, whether directly or indirectly through his family and associates, in allegations of state capture. In these exceptional circumstances, it was not only appropriate but necessary for the public protector to ensure that someone other than the President select the head of the commission. The Chief Justice was a perfectly sensible and rational choice. What remains to be considered is the President's contention that it is unlawful for the Chief Justice to appoint the judge to head the Commission of Inquiry, as the Constitution does not assign the power to the Chief Justice. There is no constitutional prohibition on the President seeking and adopting the advice of the Chief Justice. The President could, of his own accord, ask the Chief Justice to select the judge to head a commission, whether for reasons of availability or, as here, the clear apprehension of bias. In the circumstances of this case, the Public Protector's direction that the Chief Justice select the judge who is to preside over the Commission of Inquiry is both necessary and appropriate in order to render the remedial action taken suitable and effective. The President's contrary argument must be rejected. I now deal with the President's remaining grounds of review. The President contends that it is beyond the powers of the Public Protector to give directions as to the manner in which the Commission of Inquiry is to be implemented. It is the President's prerogative to select the officer to preside over the Commission, and it is also the President alone who can decide upon the issues that the Commission is to investigate, its powers, and when the Commission is to complete its investigation. So argues the President. That argument, in our view, can immediately be disposed of. For the same reason that the Public Protector has the power, in appropriate circumstances, to direct the President to establish a judicial commission of inquiry, so too does she have the power to give directions as to the manner of its implementation. The Public Protector has directed that the Commission of Inquiry is to investigate all issues using the record of this investigation and the report as the starting point. There can be no question that this aspect of the remedial action is both necessary and appropriate. Since the release of the report, further allegations of state capture have become public in the form of the so-called Gupta-leaked emails. The Public Protector's remedial relief is broad enough to encompass the investigation of these issues. As was emphasized in the EFF case, appropriate remedial action means nothing less than the provision of an effective, suitable, proper, or fitting remedy to redress the prejudice, impropriety, unlawful enrichment, or corruption that may have occurred in a particular case. The Public Protector has also directed that the Commission of Inquiry to have the powers of evidence collation, which are no less than those of the Public Protector. Paragraph 8.8 of the remedial action directs that the Commission of Inquiry is to complete its task and to present the report with findings and recommendations to the President within 180 days. It also provides that the President shall submit a copy with an indication of his intentions regarding the implementation to Parliament within 14 days of releasing the report. The allegations of state capture are of national importance. The public protector evidently recognized that it was in the public interest that the Commission of Inquiry commence the second phase of the investigation urgently and expeditiously. It is also evident that the public protector required the President to report to Parliament within 14 days of releasing the report so as to ensure parliamentary scrutiny and accountability in regard to the implementation of the report. This, in our view, was a wise and necessary precaution in order to ensure that the recommendations of the Commission are implemented and not rendered nugatory. This aspect of the remedial action is necessary, rational, and appropriate, and the President's arguments to the contrary must be rejected. Among the reasons advanced by the public protector for instructing the President to establish a commission of inquiry are the following. She lacked adequate resources, she had not completed the investigation, and her term of office was coming to an end. She also had concerns about what is referred to as the limited qualifications and experience of her successor, Advocate Mkhwebane. The President contends that these reasons are irrational and could not have constituted a lawful and proper basis for her to take remedial action. The President asserts that the lack of financial resources, if true, could have been addressed by approaching Parliament for funds. The public protector counters this assertion by pointing out that she has never been provided with sufficient financial and other resources to complete the investigation into state capture. The investigation has been hamstrung, according to the public protector, by the late release of funds, and that situation was compounded by the inadequacy of the funds allocated, which amounted to 1.5 million rands. In her answering affidavit, the current public protector emphatically states that it is not possible for the Office of the Public Protector to finalize the investigation due to a lack of resources. These allegations are not seriously disputed by the President. The President's assertion must thus be rejected. The President advances the argument that it was irrational for the public protector to instruct him to establish a commission of inquiry because the public protector's term of office was coming to an end and because she had concerns about her successor's ability. In our view, the public protector's concerns were entirely justified and rational. It was important that the matter be finalized as soon as possible, and there would inevitably have been a delay if she passed the matter on to the new public protector. Advocate Mkhwebane would have had to start from scratch. She would have had to familiarize herself with a veritable mass of information and documentation. This would have seriously delayed the finalization of the investigation. Advocate Mkhwebane's qualifications were, in our view, only relevant as to the amount of time it would have taken her to complete the investigation, and this was therefore not an irrational consideration. It is settled law that where a decision is challenged on the grounds of rationality, the court is obliged to examine the means selected to whether they are rationally related to the objective sought to be achieved. The three reasons given by the public protector for the taking of the remedial action satisfy that rationality test. In the premises, the President's review on the basis of the aforesaid three grounds is groundless and falls to be rejected. The EFF, UDM, and COPE submit that the President has preempted his rights of review. The basis for this submission is that subsequent to the issue of the report, the President told Parliament and publicly stated that he intends to establish a commission to investigate the allegations of state capture contained in the report. In so doing, so the argument goes, the President has acquiesced in the public protector's findings and the remedial action. In his replying affidavit, the President disputes that he has preempted his review rights. He states, and I quote him, "Firstly, for me to have preempted my right to challenge the impugned remedial action, such preemption must be shown that I have acquiesced unequivocally. The evidence shows differently. I consistently made it plain that the implementation of the impugned remedial action would be unconstitutional for reasons already advanced. It is therefore factually wrong that I have acquiesced unequivocally. Secondly, all my statements referred to by the respondents that I have stated that I will appoint a commission of inquiry did not say that I would do so in furtherance of the impugned remedial action." I close quotes. The legal principles pertaining to preemption are well established. What emerges from case law is that the common law doctrine of preemption applies to judgments or orders of court. Preemption, like waiver, is not lightly presumed, and the onus is upon the party alleging preemption to establish conduct that clearly and unconditionally demonstrates acquiescence in and a decision to abide by the judgment or order. In his heads of argument, counsel for the President submitted that, and I quote, "A statement by the President that they have decided to appoint a commission of inquiry is not a judgment, neither can it be deemed to be a civil judgment to qualify as a preemption," close quotes. As we understand the argument, what is in fact contended for is that the remedial action is not to be equated with a judgment or order of a court, and therefore the doctrine of preemption is not applicable. We do not agree with that submission. The public protector's remedial action has all the attributes of a judgment. It is binding and has the force of law, and its legal consequences must be complied with or acted upon. Compliance therewith is not optional, and it has binding effect until properly set aside by a court of law. The President's assertion that his utterances in Parliament and in the media did not amount to an acceptance or acquiescence in the remedial action cannot be accepted. On a proper reading of the statement released by the Office of the President on 26 May 2017, it is plainly evident that the President was not opposed to the implementation of the remedial action contained in the Public Protector's State of Capture report, and that reports to the contrary were incorrect. This was a clear intimation that the President accepted the remedial action contained in the report relating to the establishment of a judicial commission of inquiry. Furthermore, the statements made by the President in the National Assembly are not ordinary statements, but were made in Parliament before the legislative body to whom the President is accountable. They were made by the President in his position as head of state. Section 92(2) of the Constitution provides that members of the Cabinet, which includes the President, are accountable collectively and individually to Parliament for the exercise of their powers and the performance of their functions. By his utterances in Parliament and in the press statements issued by the Presidency, the President has indicated in the clearest possible terms that he accepts the necessity of establishing the Judicial Commission of Inquiry referred to in the remedial action contained in the Public Protector's State of Capture report. This undoubtedly, in our view, amounts to a preemption of the President's right to review the remedial action. For these reasons, none of the grounds of review has any merit, and the President is not entitled to the relief that he seeks. The remedial action taken by the Public Protector is lawful, appropriate, reasonable, and rational. In the circumstances, the President's application cannot succeed and must be dismissed with costs. I proceed to deal with the issue of costs. There could therefore have been no doubt in the President's mind when initiating this application seeking, as he did, to challenge the public protector's power to constrain his power through remedial action, that his own powers were not untrammeled in the face of such remedial action. The overarching basis for the remedial action challenged by the President is that he is personally implicated in the malfeasance and improper conduct investigated by the public protector. The personal conflict of the President presents an insurmountable obstacle for the President and lends credence to the conception of the remedial action by the public protector. Additionally, the statement by the President to the media and in Parliament expressing an unequivocal intention to establish a commission of inquiry and thereby preempting any justifiable basis to challenge the remedial action points to the reckless misconception underpinning the President's application seeking to review and set aside the remedial action. The review application was a clear non-starter, and the President was seriously reckless in pursuing it as he has done. His conduct falls far short of the high standard expressed in Section 195 of the Constitution. Taking all the circumstances sketched and the considerations made, we are of the view that the President was ill-advised and reckless in launching the challenge against the remedial action of the public protector. He is aware that since allegations of state capture initially surfaced, and more so after the public protector's report, the matter remains in the public domain and requires decisive action and resolution. His court challenge has resulted in further delaying the resolution of the state capture allegations. We make the point that the public protector's report has uncovered worrying levels of malfeasance and corruption in the form of utter disregard of good corporate governance and principles, some bordering on fraud, in government departments and SOEs. This invariably involves large amounts of taxpayer funds and state resources. The insidious distraction mentioned by the Supreme Court of Appeal in the Mail and Guardian case is a real prospect if this is not addressed decisively. In our view, the President had no justifiable basis to simply ignore the impact of this corruption on the South African public. His conduct also falls far short of the expectation of him as head of state to support institutions of democracy, such as the public protector. The remedial action of the public protector presented him with an opportunity to confront and address the problem. Our view is that the President had no justifiable basis to launch the review application in the circumstances. In doing so, he was reckless and acted unreasonably. Our view, this is a proper case where a personal cost order is justified and should be granted. In the premises, the following order is made. The application is dismissed. It is declared that the remedial action in the Public Protector's Report number 6 of 2016-2017, dated 14 October 2017, and entitled State of Capture is binding. The President is directed to appoint a Commission of Inquiry within 30 days, headed by a judge solely selected by the Chief Justice, who shall provide one name to the President. The President shall take all steps, do all things, and sign all documents which are necessary to give effect to the remedial action. Without limiting the generality of the foregoing, the President shall ensure that the judge who is to head the Commission of Inquiry is given the power to appoint his or her own staff and to investigate all the issues using the record of the Public Protector's investigation and the State of Capture report as a starting point. The Commission of Inquiry is to be given powers of evidence collection that are no less than that of the Public Protector. The Commission of Inquiry is to complete its task and present its report with findings and recommendations to the President within 180 days. The President shall submit a copy with an indication of his or her intentions regarding the implementation to Parliament within 14 days of releasing the report. The Commission of Inquiry is adequately resourced by the National Treasury. The Public Protector shall deliver a copy of this order to the President and to the Chief Justice within 5 days of the grant of this order. The cost of this application are to be paid by the President in his personal capacity on the scale as between attorney and client, including the costs consequent upon the employment of two counsel. The costs are to include the costs of the public protector's conditional counter application.
I agree.
I agree.
I hand down the judgment.